All right, we're back on YouTube and we're still on the record on People versus Chayse Hardy. And again, Mr. Hardy has indicated he is ready to proceed with sentencing. We have the victim here now. And Mr. Hardy pled to the charges pursuant to his plea agreements in all these cases. I'll start out with the order of the cases and here first 2023211. I've got just a couple of typographical errors that I found in the report, and counsel probably has those also, but let's straighten those out. In page 6, okay, in the middle of that second paragraph, in the middle of the, about the fourth line from the bottom of that paragraph, also seen on the video, the subjects are falling into the TV and stumbling. Right now it reads, the subjects falling into TV and stumbling. So I just put in the R. On page 11, fourth paragraph, last line, they all back to Newton's house to smoke weed. I assume it meant to say they all went back to Newton's house to smoke weed. So those were the only corrections I found in the report. Ms. Yancey, do you have any corrections in the report?
No, Your Honor.
Mr. Sapanos, do you have any corrections in the report?
No, Your Honor.
Mr. Bush, do you have any corrections in the report?
I have no corrections. I discussed the case this morning with Mr. Hardy, and he did not specifically identify anything that was inaccurate in the report.
Okay. Mr. Gabriel, do you have any corrections?
I do not, Your Honor.
All right, the plea agreement in these cases, it was a package plea offer for all the cases. And in file 2023211, as I said, he pled to a charge of assault with a dangerous weapon, a felony punishable by up to 4 years in the Department of Corrections. The plea agreement involved dismissal of count 2, failure to stop at the scene of a personal injury accident, and to dismiss the habitual offender third offense notice. In case 2023229, where he pled to charge of criminal sexual conduct in the third degree involving a person between the ages of 13 and 15, a felony punishable by up to 15 years, and felon in possession of a firearm, a felony punishable by up to 5 years, the plea agreement involved dismissal of counts 2 through 7, which were all counts of criminal sexual conduct in the third degree involving a person between the ages of 13 and 15, dismissal of count 9, criminal sexual conduct in the fourth degree involving the victim between the ages of 13 and 15, and dismissal of the habitual offender third offense notice. And in file 2123763, he pled to a charge of unlawful imprisonment, a felony punishable by up to 15 years in the Department of Corrections. The plea agreement there involved dismissal of counts 3 through 4. Count 2, unlawful imprisonment, and counts 3 through 4 of assault with a dangerous weapon, also known as felonious assault. In all the documents, prosecutor agreed to dismiss also 2123764, 20929SM. Prosecutor would recommend the minimum sentence not exceed half of the guideline range, all cases to run concurrent with each other. The prosecutor agreed not to charge absconding, and the defendant agreed to pay a restitution of $411.88 for file 20929SM that was going to be dismissed. So that is the entire contents of the plea agreement. So in terms of scoring, in file 2023211, the agent recommends the prior record variable be scored at 40 points, level D.
No dispute, Your Honor.
I have none, Your Honor.
In the offense variables, the agent recommends 56 points under offense variables.
Your Honor, I would just argue offense variable 9 should be scored at 0. It's listing its 2 or more victims. The department scored the passenger in the vehicle, but if you look at the body of the report, the passenger didn't even think that the victim was even hurt. I would argue there's no danger. It's still going to keep it a level 3 if it goes down to 46, but I would argue that that should be 0.
All right, OV9 is scored, the agent recommends 10 points for there being 2 to 9 victims placed in danger of injury or loss of life.
It's the position I would take, Your Honor, is that Mr. Hardy had a passenger in the vehicle when he decided to use that vehicle to try to run down the victim in this matter. We all could anticipate that that could create some kind of problems, loss of control of the vehicle, which could not only injure the victim, the person who got hit by the car, but the person that was in the car with Mr. Hardy, as well as Mr. Hardy.
Okay, let me review the file for a moment. All right, a very detailed description of the offense occurred, but the relevant portion indicates that Officer Dibble requested to view the surveillance camera from the store clerk. The video showed that Klozinski walking westbound down the sidewalk, and the vehicle that was driven by the defendant and had a passenger in it can be seen speeding up quickly, striking the victim in the back. It doesn't appear that the victim, who was walking in the middle of the sidewalk, saw the vehicle coming. At closer review, Officer Dibble notes the victim's head was nearly ran over by the car tire as the vehicle drove on. He also notes that the victim was struck, vaulted into the air, and his right foot struck a merchandise sign, causing damage. Also further noted that debris fell on the ground next to Klozinski. Clearly, she was placed in danger of injury when the defendant accelerated the vehicle to run over a person walking on the sidewalk. I find that it's properly scored at 10 points. Note the defendant's objection. Any other challenges to the scoring?
No, Your Honor.
All right, that calls for an advisory guideline of anywhere from 10 to 23 months on the minimum.
I believe that's correct.
In that file. 2023229FH. The agent recommends the prior record variable be scored at 45, level D. Any objection to that?
No, Your Honor.
Your Honor, I do note that on that line item, there's 3 entries. In the other 2 files, there's only 2. I don't think it matters, but I in case this comes back later, I don't know if it's supposed to list my own case in there. I'm not. On the other.
Where are you talking?
PRV 7.
What do you mean that
Well, see how it lists convictions and dockets, and it lists mine, and then the other 2 we're here on today. When you go to the other worksheets, it only lists 2 of those, and I don't know that it matters, Your Honor. I've never seen that, but it's a little different. See, it lists mine, then the other 2. If you go to the other worksheets.
Oh, you're talking about the worksheet. No, PRV 7 is scored for subsequent or concurrent convictions. If there are 2 or more subsequent or concurrent convictions, score 20 points. In this case, there's 4 concurrent convictions. So it doesn't matter on the worksheet doesn't go anywhere. It's just provided to the court and to the attorneys for the agent's explanation. I do find PRV 7 is properly scored at 20 points as there are 4 separate concurrent convictions here. So, but so yes, I don't think that matters. So 45 level D is the prior record variable. Any objection to that?
No, Your Honor.
Yeah.
Okay, offense variable 110 points, level 6. Any dispute with that? As to criminal sexual conduct in the 3rd degree.
Your Honor, I think prosecuting attorney Gabriel and myself have agreed on OV1. I'd ask that that be 0, and I think he's in agreement.
Your Honor, I would prefer if counsels would let me speak for myself. When I left the breakout room, our discussion was about information about, first of all, there's 2 issues here. One is, and the court's obviously going to rule on whether or not OV1 should be scored at all. Okay. Then we deal with OV1 being scored at 15 against Mr. Hardy because a gun was placed in the defendant's mouth during the night and the guns remained out throughout the night. It is very clear in my initial conversations with Mr. Sopanos, and I'm not trying to sandbag anybody, was that, yes, it was very clear that the reports had identified that the co-defendant Wood had done this. And I had indicated in that conversation that I thought I had read something in this report that indicated both individuals did it. For other reasons, I left the breakout room early and I have reviewed the report. So as to the issue of whether or not Mr. Hardy did do the act described in OV1, I would direct everybody's attention to page 15 of the pre-sentence investigation. The bottom half of that page, and everyone's at it, this is CSJ 284. Preliminarily, we all have to realize, and if we've all reviewed the information that's been provided by the law enforcement, we understand that both Mr. Wood and Mr. Hardy were distinctively dressed that evening when they were dressed. And relying on those distinctive dress situations, Mr. Wood was an individual that was wearing one outfit, and Mr. Hardy was an individual wearing a different outfit. What I read in the pre-sentence report and wasn't in the original body of the report provided was that Mr. Newton's home video was acquired by the police, his own security cameras. And the court sees on the bottom half of that page an itemization or a timeline at which various things were seen. At 23:15 hours, the male suspect wearing the hooded jacket puts the barrel of the handgun in the female's mouth. That hooded jacket, based on my recollection, was worn by Seth Wood. But if the court looks just prior to that, at 23:14 hours, 2 male suspects and the female are standing next to the SUV in the driveway. The male suspects, because there were multiple guns, begin to display the handguns and appear to be taking photos while holding the handguns. The male suspect in the yellow sweatshirt, which is identified as Mr. Hardy, puts the barrel of the handgun in the female's mouth. Both individuals did do the physical act. One video was captured from evidence from the defendants that was there. So point 1 is that the gun was placed in this young lady's mouth by both individuals. So I wanted to clarify that. That's why I left early. I'm not trying to say we had an agreement or anything. I'm reading these pre-sentence reports. That's why we always indicate that any sentence recommendation is based on the scoring as found by the court, not what I thought it might be or what defense counsel thought it might be, but what the court agrees it is. The next question then, obviously, and I believe Mr. Sopanos also feels, well, I'm not going to speak for him because then I'd be doing the same thing. So as far as the factual element, I think the pre-sentence report clearly establishes that he did do the act.
Well, then we got a
Question
problem,
is-
then we have a problem, Your Honor.
I love it when you interrupt me.
Oh, sorry, Your Honor, I didn't hear you,
yeah.
sorry.
The trouble we're dealing with is that we're dealing with two separate crimes. One is the statutory rape crimes that he pled to of the C.S.C. third. And then two is the possession of a handgun. Now, the handgun was in the room at the times, but what you're talking about in page 15 is what occurred outside, when the three of them went outside. Separate from the C.S.C. case, it occurred outside by the SUV. And so it's a separate act. And again, there's no allegation that in the course of the C.S.C. they used the handgun. So I don't find a basis to score it under the C.S.C. and will not score OV1 on the C.S.C. charge.
Thank you, Ron. That's fine.
I won't score OV2 in the C.S.C. charge.
Fine.
All right, now, any other challenges to the scoring of the offense variables for the C.S.C. charge?
Yes, Your Honor.
Go ahead.
OV10, defendant provided the victim with alcohol, encouraged her to drink.
Okay,
I wasn't there, but the information that I've been provided with, and I, by the way, just so we're on the record, I was provided 3 DVDs, Chase Hardy's phone extraction, Chase Newton's phone extraction, and an interview with Seth Wood. On those, I don't see any video where 2 boys are putting a gun in a girl's mouth. I don't have that video. If it exists, I need to see it. But let's move on from there, because I didn't see that, Mr. Gabriel, just so you know. So the next one, OV10, defendant provided victim with alcohol, encouraged her to drink. The way I read it, the information that I have is that they went to Mr. Newton's house, the adult who provided all the guns and all the alcohol. And on the way there, they didn't have alcohol. It was after they got there that Mr. Newton drove to Meyer and bought everybody alcohol.
when I read the pre-sentence report, I seem to remember several of the, either Mr. Hardy or Mr. Wood or the victim indicating that when they picked her up, they had a bottle of vodka. They drank all of that, and then they begged Mr. Newton to take them to Myers and get more. So that's what I had somewhere in this report. Does anybody know where that's at, or am I reading it wrong?
You look at page 6, Your Honor.
Yeah, there it is, the last paragraph. The victim reported that Wood was driving the vehicle when he and Hardy picked her up from her residence. She describes the vehicle. She reports that she was drinking alcohol while Wood was driving crazy-like. She explained that they stopped at Lockport Liquor and bought Swishers and Black and Milds, and she indicated that she remained in the car while the guys went into the store. Thereafter, she believes that they traded places, and then Hardy drove into an unknown residence. So it does describe them having alcohol and marijuana before they got to the home, and it was provided to her. So I do find it's properly scored there. But I'll note your objection.
She reports she was drinking alcohol. Is that, I see that, Your Honor, but she does not say that my client or Wood provided it.
She didn't walk out of her home with it.
How do we know?
Because it says in the report that they picked her up and they had it in the car.
My guy denies it, and when I read Wood's statement, he doesn't say that they had alcohol in the car, but hey, I just put my objection on the record.
Okay, Well, we can have an evidentiary hearing regarding that. Maybe I'm wrong, and maybe the report is misleading me. We have the victim here. Let's ask her.
Yeah,
All right, miss, you're here today. You're the victim in this case. Is that correct?
Yes,
Did you bring the alcohol or did they provide the alcohol?
they provided the alcohol.
Any follow-up, Mr. Sopanos?
yes. You heard that paragraph read that when they picked you up, there was already alcohol in the car. Is that true, or did the alcohol come when you guys went to Meyer?
The alcohol was in the car when I got in the car, when they picked me up.
Okay, thank you.
All right, the victim having testified that it did happen, I find OV10 is properly scored. Any challenges for the next ones?
No, Your Honor.
All right, so taking away 20 points would make it a 90 offense variable. And in a B-class felony, and again, double check my math because I'm notorious for not being good at math.
You're 90.
90, okay.
And 75
So-
is,
D90 would still be a level 6. So it would still be 84 to 140 guideline range. All right. Now that's the felon, C.S.C. count. On the charge of felon in possession of a firearm, here, 45 level D, that's been agreed to. Here, offense variable 60, level 5. And here is where that issue regarding the weapon, again, he must have, he pled to the charge of felon in possession of a firearm, so I don't assume he's disputing that he had a firearm in this charge, but Mr. Sopanos, any objections to the scoring in this one?
He on OV1, Your Honor, he still maintains that he never put a gun in the victim's mouth. She's here.
Okay.
If we want to inquire of her of that, I would have no objection.
you know, you can strike it. We won't change. You can
You're
remove
not
it.
going to argue about it?
I'm not going to
Okay.
argue on it. Since
But just so we're clear, in multiple offender situations, if one defendant is charged, both defendants are scored with this. So if one defendant is assessed points, both are to be assessed points. So it doesn't matter if only one did it in a multi-offender situation, as long as one did it. But if Mr. Gabriel's not going to argue it, then I won't score it. But I just want to set a record that, you know, that's that. Okay, so what about the rest of the offense variables? Any objections?
Not for me, right?
Mr. Spanos, any others?
Your Honor, I'm looking at 14.
Okay,
I agree with the first two prongs of the scoring, but the second one asked that guns be brought out. I don't know that that would change it. I don't know that that would change it, so I don't have any further objections, Your Honor.
okay, so that would make it 50 points. And again, this is a E-class felony. So 45D, correct? And 50 would be a level 5, doesn't change anything. 14 to 29 would be the advisory guideline range for that count. And the charge of unlawful imprisonment. And here it's Mr. Bush, and Mr. Bush, the prior record variable is scored at, recommended to be scored at 50 points, level E.
I do not
Any
object
cha-
to that scoring.
Okay, Mr. Gabriel?
No problem with it, Your Honor.
And offense variable is 86, level 6.
I do not object to that scoring.
Nor do I, Your Honor.
All right, 58 to 114 months on that count. All right, so now what we'll do is I will go through with each counsel their allocution, which is what they want me to know in terms of sentencing. I will do it in the order that we did, and then I'll hear from Mr. Hardy, and then I'll hear from Mr. Gabriel, who will introduce, who will offer the victim an opportunity to speak as to how the case has affected her. We only have one victim here today, and no one else has shown up, and they've been provided notice. With that, the first case is the assault with a dangerous weapon, 2023211. Ms. Yancey, what would you like me to know in terms of that case?
Thank you, Your Honor. In terms of this case, all of these cases are going to run concurrent. So my case is one of the lesser guidelines. I would ask Your Honor to consider scoring on the low end of the guideline based on the recommendation on the other files.
Okay, thank you. Mr. Sopanos, your case is 2023229, and he is being sentenced on one count of criminal sexual conduct in the 3rd degree involving a person between the age of 13 and 15, and one count of felon in possession of a firearm, a felony punishable by up to 5 years. And we have gone through this a little bit in terms of the scoring. It is a statutory crime. Having sexual relations with a victim who is between the ages of 13 and under the age of 16 is a felony. And then felon in possession of a firearm. What would you like me to know in terms of your case, Mr. Sopanos?
Your Honor, I think what you have before you is a young man that was headed completely down the wrong path. And I think both of his parents would agree that although this is a very, very tragic and sad and remorseful situation, and no young lady should have to go through what this young lady did, I truly believe that with whatever time you give Mr. Hardy, that he's going to come out, if he uses the services available to him, a better person. I know that his mother, who I've got to know well, and his father, who I've got to know recently, both are squarely behind this young man. And it's hard to say this as a lawyer, but it's almost good that he was picked up and he's been sitting in jail and he's had time to reflect on these matters. And he hit the Hardy that's here today is definitely different than the boy I met when his folks first hired me. And I'm not a psychologist, but I think that this young man has to use, and to his benefit and to society's benefit, every option available to him in prison, rely on the love and caring of his parents. Think about everything that happened during these occasions and every other time he did something illegal or immoral. And I believe that he has the capacity to come out a better man. I don't think he's going to be one of those guys that goes in there and falls further and further and further into the wayside. I think that if anything was going to help him get back on track, and not continue to head off in the wrong direction, that a prison sentence, unfortunately, is going to be, although a detriment to him now, a benefit to him later. And I believe, as I started to say, that he will utilize all resources, rely on mom and dad. I think he's truly, truly remorseful. I don't know that if he was in his right mind a lot of times. I know there was alcohol and drugs and everything involved. Not excuses, Your Honor, because he had to self-ingest them. But based on my conversations with him, I think he's going to try to turn all these acts and criminal violations from negatives into positives, and he's very remorseful for the incident and the time with the young lady. I ask that you serve on or sentence on the low end of my guideline, Your Honor, which would be the high end of Mr. Bush's guideline. And I hope he takes advantage of everything.
All right, thank you. Mr. Bush, what would you like me to say, or what would you like to say to me on this case?
Well, thank you, Judge. We're dealing with Chayse Hardy, who's 20 years old, and he's really been through a lot. I think it's commendable that he has long-term services with Dr. Menthonol. Obviously, he has the family support trying to get him the services to make better decisions. When I talked to him, he acknowledges mental health and substance abuse issues. It's obvious he needs treatment. He told me when we first met, he needs structure. And, that's probably true of a lot of young adults. Today's been a real dose of reality to him. There's no question about that. 20 years old, and the question is not if, but how long you're going to be spending in Department of Corrections is an awful thing for somebody to face. He's certainly made a number of bad decisions, but I would ask that because of his age and the fact that he recognizes he needs to make changes, that you would sentence him on the low end of the guidelines.
Thank you. Mr. Hardy, what would you like me to know?
I'd like to read you something. It says, Your Honor, I would like to start this off with thanks for your time in the court's time. I know you guys got a lot going on. Also, I'd like to say sorry to everybody I hurt and did wrong to in St. Joe County, especially my victims. As I sit and think about what I did wrong, I'm realizing I'm not the only one affected by the bad choices I chose to do out there. I hope they will accept my apology. I am getting older. I'm starting to realize life is not a party. That's my biggest downfall. I'm at the point in life where I need help, but to get help, you gotta wanna help yourself. And I'm ready for that point. I accept full responsibility for my actions and behaviors. This time has been a huge wake-up call on me. I'm asking Your Honor to consider a program structured for me. I am ready to prove to myself and the courts, plus my family, I can do it. I feel like Swift and Sure would be great for me. It will show me how to be a good young man, get me back into school, get me in classes. Since I've been in jail, I started to go to a class in here called Meth Madness by Preston. I would like to go to Twin County Probation Center, get me a job, complete school, take anger management, do community service, and just show you, Your Honor, I can do this. I just need a little help. I feel like right now is the best time in my life while I'm 20 to teach me certain things than for me to be 40 asking for your help. Thank you for your time to listen to this, Your Honor, and once again, sorry for wasting the court's time. Have a blessed day.
Thank you, Mr. Hardy. Mr. Gabrey?
Thank you. Your Honor, we have in the virtual courtroom the young lady that is the victim in criminal sexual conduct charge. I have had extensive conversations with her and her mother. Ma'am, do you wish to address the court? You don't have to.
Yes, I do.
Okay, please go ahead.
Your Honor, after this crime, my life has just completely changed. I can't even go to school and focus without flashbacks of what happened. And I couldn't go to work for a very long time because he kept coming through my drive-thru and making faces at me and laughing at me and causing me more trauma. And I just ask that I didn't feel remorse at all, honestly, after he came through over and over.
Hello? Okay, is that it? Thank you very much. All right, Mr. Gabrey. One thing I need from you before we begin is some math help.
Okay.
And I hope all counsel will do that, but the Department of Corrections makes their recommendation, but I'm not sure. I just want to be clear, so I'll hear from you, but the plea agreement involves a recommendation from you that the minimum sentence not exceed half of the guideline range. And so if you could tailor your arguments to that, because it seems to me that in the guideline range of 10 to 23, that a recommendation of 18 months would be above the halfway point of the guideline range in the first case, and I haven't looked at the other two.
Your Honor, that, and I will, and of course, I was one of the people in here yesterday, and I did all this math, and now do I know where that piece of paper is? No.
Well, Ms. Yancey, what's your understanding in your case of what is the halfway point of a 10 to 23 guideline range? You're muted.
I believe it's 16 months.
Yeah,
Yes.
I was thinking 16 would be the midpoint on my guideline.
Okay, good. That's what I had too, but I'd like it for all of them if you could, Mr. Gabriel, but go ahead.
Okay. What I can indicate to the court is, first of all, as to that issue, although I don't have the numbers in my head, I know that as I looked at the guidelines as they were scored, and the only change, no, and it wouldn't change, even because we never moved, at least in the two major cases, we did not move a cell. So we're still in the same cell. And in both situations, both in Mr. Bush's case involving the unlawful imprisonment and in Mr. Sopanos's case, the recommendation of the Department of Corrections was about 1 month below the midway point of the guidelines. So I apologize for the court. I have no idea why I didn't put that right on the top of everything, but I thought that this might come up. And I certainly didn't know how the Department of Corrections was going to do it either. So I did verify that in those two cases, they were below it. They were not much below it. They were pretty much right at the halfway point. In a lot of ways, I'm kind of speechless, and I don't envy the court. These are the kind of cases that we have so many dynamics in play. The thing that struck me the most, I guess, or started to strike me the most is it's always hindsight. And I know Mr. Hardy is watching me, and I just keep thinking how we wouldn't even be here if when he drove that car for whatever reason he had, and this man that he didn't get along with, and hit him with the car, and his family put him out on bond, if he would have taken half of what I've heard from the two all attorneys seriously, he wouldn't be sitting here. None of this would happen. He was on bond when that happened. He was on a district court bond for domestic violence against the young lady who was in the car. Fortunately for him, the person that he hit had some injuries, but they weren't life-threatening, and he healed, and life would have went on. Instead, Mr. Hardy gets out on bond, and I realize, you know, even with his history, there may have been a reason that he's out on bond, and we can't forget that history. This is a young man, an adult now, who started his court involvement at the age of 13 and had significant resources by the probation or by the probate court, Eagle Village, counseling, all of that. He was waived and prosecuted as an adult when he was still a juvenile. He then gets involved in misdemeanor problems and starts out with a new crime that was the front end of a binge that, frankly, it was like something out of some gangster movie. And I don't know who he thinks he impresses by conducting himself that way with his hangers on and his video identity and his Snapchat videos. But he certainly created his own viral grouping. And I thought it was amazing to me that on the day he was supposed to appear in court, Mr. Newton has to wake him up from his drunken sex binge to say, oh, you're missing court. Mr. Wood had already left, and this young lady had to walk back out of the country to find her way home. So what happened on that case is terrible. As a parent of a boy and a girl, it's all of our worst nightmare that young people are going to go out there and live this crazy fantasy lifestyle and not know how to draw lines, not know and have the respect or the empathy for somebody else, but to use that person, even if that person initiates or feels that they're going to go along. But is that the end of the situation? No, it's not the end. I mean, we turn around and we've got the whole gangster lifestyle. I dismiss cases in which he again was out on bond and ran from the police and overdosed. Kind of culminates in him grabbing a 14-year-old. I don't know if he was one of his hanger-on or whatever, but basically terrorizes that kid. Hits him with a liquor bottle, won't let him leave. I never like to see young people put into the Department of Corrections, but the fact of the matter is this young man has I don't think the court has an alternative. I know that there may be a lot of questions in the court's mind about the parole process, but giving him the top of what I asked, the ceiling that I indicated, will give him plenty of opportunity to complete programs, plenty of opportunity to demonstrate that he's learned from not only these actions, but from what he's been in prison. And hopefully, if he conducts himself as he appears to right now, as a respectful young person, the board will see that he's no longer a risk. But I do think that he has demonstrated no reason for the court to provide sympathy, not just a poor troubled person who suddenly shows up. The court system of this county is well aware of his antics, and I think it's time we need to put a long stop to those. Thank you, Your Honor.
In terms of the restitution for the file that was dismissed, who does that get paid to?
Oh,
The $411.88 for the misdemeanor file. I didn't write it down.
I didn't either.
is that Miss Crippen?
It was a misdemeanor case. I don't have any information on it. Maybe Marissa does, but I don't know who to make it up to. All right. In any event, we'll order $411.88. The prosecutor will provide us the name, and this is for file 20929SM. And that will be applied to one of the files, and I'll get to that. So let's start in the order that they occurred. In file 2023211, this is a chart. Marissa, you have something? That's, maybe text Mr. Gabriel, because you must be in the mountains somewhere because we can't hear you. Okay, in file 2023211 on the charge of assault with a dangerous weapon. Again, Mr. Hardy is in a vehicle. He's in Broadway Market. He runs into a friend that he sees. They don't show any signs of any animosity. He leaves, gets into a vehicle, and waits for the other gentleman to leave the store. And then he is in a vehicle with a person he's supposed to not be having contact with because he's facing a charge of domestic violence that she made against him, but yet she's with him, and they're in a car. And he decides to try and run down this gentleman, and then leaves the scene almost running over his head while he's on the ground. So in that case, and then compounds it or makes it worse by saying that, well, he only hit him with the mirror and it's no big deal, and other excuses. So 14 months to 4 years with credit for 82 days served, $68 state cost, $130 crime victims assessment. And Mr. Hardy, in that case, you are receiving 3 forms advising you of what your rights on appeal are. I'd ask you to sign 1 copy acknowledging that you received them. If you wish to appeal, you would need to fill the rest out, return them to the court within 42 days. File 2023229, 2 counts, 1 of criminal sexual conduct in the 3rd degree, involving a person between the ages of 13 and 50. In this case, Mr. Hardy, you planned, along with a friend, to meet up with the victim. The victim contacted you about the situation, was in agreement for it, but what she may have been in agreement for part of what happened, but not the whole thing. You ply her with liquor, you ply her with marijuana, and it's not like you forced it on her, she willingly took it. But then the 2 of you sexually had sexual relations with her, contact with her. She was not of age. Your argument that you don't ID people, but you know, that's the risk you take, maybe you should, because she was only 15 at the time, and it occurred a whole night long, to the point where you were so passed out after throwing up over yourself in the bedroom that you pass out and wake up the next morning, you know, having consumed various alcohol and drugs, that you don't even know what's going on and have to be told to leave because you have court in the morning by the place you took. You took her to her home of a friend that she didn't know where she was. And then to compound it, I don't know what's going on with the, you know, not to sound like the old guy, but you're in the middle of committing felonies and you decide to put it on social media at the time that you're doing it, so that, you know, people contact you and say, hey, she's listed as a runaway. You know, the argument that you didn't know what was going on, that you didn't know what was involved, just doesn't hold any water. And she tells you that, you know, she's tired of it. She wants, you know, she can't do it anymore, and you keep insisting, the 2 of you, to where you then pass out. Then at some point you pull out a gun, and again, put this on social media where you're in possession of a gun when you're not supposed to, and the 2 of you are putting it in her mouth and you know, displaying that on social media for whatever insane purpose that you're doing. It gets out there too, and there's videos of that to be used for whatever reason. I mean, I don't know which one was live. I know one of them was live because people were commenting on it to you, like, hey, she just left our house. So again, here on the C.S.C. third offense, the guidelines call for a sentence of 84 to 140. Your plea agreement is for no more than halfway. And so I'm going to order 8 years to 15 years in the Michigan Department of Corrections. Credit for 34 days served on the count of C.S.C. in the third degree. That's below the recommendation of the Department of Corrections, but I just want to be comfortable that I'm within that plea agreement and not going to have that issue on appeal. 2, on the felon in possession of a firearm count, 16 months to 5 years on that count. And again, you're given 3 forms advising of what your rights on appeal are. In that case, there's a $68, in all these cases, there's a $68 state cost, $130 crime victims assessment. So,
There should be 2 state costs.
yeah, let me finish. In the first file, there was a $68 state cost, $130 crime victims assessment. In this case, there's 2 $68 state costs and one $130 crime victims assessment. So take out the second one that's recommended by the Department of Corrections. And then in file 2123763 on the unlawful imprisonment, where you take 2 of your followers, again, ply them with alcohol, they're underage, they get them drunk. You refuse to let them leave for whatever reason, and then you hit them with liquor bottles. Again, you terrorize these 2 young people. You only pled to one of them. And so there, the guideline range is 10 to 23.
Oh,
No, that's the first case, sorry. This one is 58 to 114. Okay, I have the halfway point being 86 months. Okay. So I'm ordering 7 years to 15 years on that case. All files to run concurrent with each other. And in this case, there's 81 days credit. And in this case, there's a $68 state cost, $130 crime victims assessment, and in this case, there'll be restitution for the dismissed file, $411.88 to,
I will get you the name, Your Honor.
okay, I thought maybe you had it, okay.
No, I don't
We'll
have
get
it.
that name. What?
He said, no, I don't have it.
I thought she said something.
No, it was Gary.
Okay, so with that, again, in all cases, you've been given 3 forms advising of what your rights on appeal are. I'd ask you to sign 1 copy for each file, acknowledging that you received them. If you wish to appeal, you need to fill them out, return to the court within 42 days. I sentenced below the halfway point pursuant to my calculations, but these cases are resolved within the plea agreements. So we are excused